What's up, everybody? Welcome to my channel. I'm Sunshinery. Make sure to subscribe and like this video.
Never break, always fight, never quit, do it right, play the game, win it life, have no shame.
What's up, everybody? Welcome back to my channel. We are here today to talk about a new lawsuit, and this one is not with Ariana. This one is with Lisa Vanderpump and her husband Ken, and it is for wrongful termination of 2 employees at their Tom restaurant, which I don't know if that means any issues will come of it, since, we know the Toms own a percentage of it. If they will be part of this lawsuit, we will have to wait to find out more on that. But let's get into this, and I also have an update on Tom and Ariana's case. So make sure to subscribe to my channel and make sure to hit that notification bell so you get notified every time I post a video or go live, so you don't miss these updates for now both of these court cases. So first up, we're going to talk about Lisa Vanderpump and Ken Todd and how they are being sued by former Tom employees for wrongful termination. Now, Lisa, who is 63, and Ken, who is 78, allegedly fired bartenders from the restaurant in retaliation for complaining about the working conditions, according to the documents that I obtained and I have for you all. Now, in the lawsuit, which was filed on Thursday, January 11th, one of the former employees claimed that Lisa and Ken blacklisted him by defaming him to future employers. According to one of the plaintiffs, Lisa and Ken published false statements and comments to numerous third parties regarding his profession, reputation, and character. The bartender claimed that they were rumors and false statements made with actual malice, which affected his career. Now, the paperwork also alleged that Tom had unsafe working conditions, including sewage and backup in the employees' break room. Ew, if that's true, that's just gross. During this period, the former bartenders experienced rampant violations of California labor laws, harassment, and unsafe working conditions that these documents claimed. Now, as we know, Tom Sandoval and Tom Schwartz are co-owners of the West Hollywood establishment, but they have not been named in this lawsuit as of yet. Tom, as we know, has also been featured on Bravo's Vanderpump Rules, since Lisa Ken owned this business with the Toms. One of Lisa's many businesses previously made headlines when news broke that Pump temporarily lost its liquor license in March of 2023. U.S. Weekly obtained a report from Alcoholic Beverage Control, ABC, which confirmed that the WeHo hotspot had its general eating license and its event permit suspended. Now, they said that they've been in Pump's location for 10 years, that they had a great relationship with the landlord, but the lease was expiring. So over those next few months, they had to decide whether they were going to stay, but they hadn't made that decision then when they were talking to US in that statement. Now, Pump has since been closed, but Sir Tom and the Vanderpump Cocktail Garden and Vanderpump Paris in Las Vegas are open for business. The business owners also have Chateau Vanderpump Village, which is located in France, and it is also set to be the center of an upcoming Hulu spinoff coming this spring, which I cannot wait for. Now, so far, no comments have been made by Lisa or Ken regarding this lawsuit. Now, let's just take a look at the documents and what they're being sued for and what the complaint that was filed on January 11th has to say. All right, so first up, we have the Superior Court of California, County of Los Angeles complaint cover sheet, where it says Lisa Vanderpump and Ken Todd are being sued by Dax Hill and Peter Hodge. Now, the complaints are for count 1, wrongful termination, count 2, retaliation, count 3, failure to prevent discrimination, harassment, and retaliation. Count 4, wrongful termination, violation of public policy. Count 5, violation of Labor Code 6310. Count 6, failure to provide rest periods, Labor Code 226.7. Number 7, waiting time penalties, Labor Code 203. 8, unlawful business practice, Business and Proof Code sections 17200. Number 9, defamation. And number 10, blacklisting. And this is the California Labor Code 1050 and 1054. So that is page 1. There is a long list of complaints here, so there is 12 pages altogether. Let's go to the next page. So this is page 2, where you can see it says, plaintiffs bring this action to recover damages against Pinky Beverly Hills, LLC, Lisa Vanderpump, Ken Todd, and does for unlawful termination of plaintiff's employment in retaliation for reporting unlawful labor law violations. With respect to plaintiff's Hill, defendants blacklisted him by defaming him to future employers. This was between May of 2022 and December of 2022 that plaintiffs were both employed as bartenders with defendants at their restaurant, Tom Tom. Now, they say during this period of time, they experienced rampant violations of the California labor law, harassment, and unsafe working conditions. It then goes into plaintiffs were part of a protected class, engaging in protected activities, yet were unlawfully terminated. And it goes into what a protected class is and how they are fit into that, which pretty much at all times relevant, reporting unlawful activities, resisting harassment, abuse, and reporting inhumane working condition, OSHA violations, and backup in the employee. So right here is where they say there was sewage and backup in the employee break and locker room. That's just gross. Sometimes things happen. Now, did they take care of it once it happened? That's the question. Was it like a one-day thing and they had to get someone in there to fix it? Or was this like ongoing for months and weeks? That's what I want to know. It then goes into the protected activities, which is reporting unlawful labor violations, request to be paid timely, numerous paychecks were late, resisting harassment/abuse, reporting inhumane working conditions, OSHA violations, sewage and backup in the employee break or locker room. And yes, that was Vanderpump just coming on while I was recording this. Also, here's the next one. Various other acts according to proof. And then it goes down to 5, which is adverse employment actions. And it's pulling plaintiffs from the schedule and not giving them shifts, constructively terminating them. And then we are going on now to page 3, which starts with plaintiff harm, which states loss of income, loss of future income, substantial and profound pain and suffering and emotional distress, other forms of economical and non-economical damage, and damage due to egregious, willful, and malice conduct of defendants through managing agents. So it goes down to their right to sue, which isn't really, it just states why they can sue the defendants, and then goes down into who the parties are, which we've already stated, but Dax Hill is one of them, and Peter Hodges is the other plaintiff, and then we have defendants Pinky Beverly Hills, LLC, which is her company, Lisa Vanderpump, and Ken Todd. I will point this out, which I did not highlight this on the bottom of page 3. It does say the individual defendants are doing business as Pinky, and Pinky is an alter ego of individual defendants in that there is such a unity of interest between the Pinky and the individual. And I was like, wait, what? Let's go on to the next page, which I didn't really highlight anything here on page 4, but I will point out on line 4, it says, in addition, the individual defendants are using Pinky's status as a corporation to shield themselves from liability for the conduct described throughout the complaint, when in fact the individual defendants are siphoning funds from Pinky for personal use to fund their other ventures. As such, an inaccurate result would acquire if the individual defendants and Pinky are not treated as one and the same. Which I do know, like, Pinky is kind of like her alter ego per se. That's what they're trying to say here. I know that a lot of her thing is Pinky. Like, so for instance, she is opening up a third location on the Las Vegas Strip, and it's going to be Pinky's by Vanderpump, and it's going to be opening up in the Flamingo, actually in the summer of 2024. So they're trying to say Pinky is her alter ego. I don't know if that's something I ever heard about Lisa Vanderpump or like on Beverly Hills Housewives when she was on that. If that is something that you guys have heard, let me know down below in the comments. I would love to know more about this. I mean, maybe I've heard it and I just don't remember, but I think maybe that's something that she's maybe even said out in public before, and people know this, and maybe it's just something I don't know. I also want to point out at number 9, it says that the defendants are sued hereon under fictitious names. Their true names and capabilities are unknown to plaintiff at the time. So they're trying to say maybe there are other names that like Lisa goes by, or maybe there are other businesses that they own, because they do own other businesses, and maybe they're saying they go under like by their business name as like an alter ego per se. I don't know. Let me know what you guys think. But really, this is what this page has to say for page number 4. I'm gonna you could pause here if you want to read it. I'm gonna move on to page 5 though. Now for page 5, it goes into jurisdiction and venue, which is where we will be holding the proceedings and where they are. And then we get into the first cause of action. Now we have 10, if you recall. So the first one is wrongful termination. And I just highlighted the important stuff, which is at all relevant times, there was an employer/employee relationship between the plaintiffs and defendants. And on or about December 1st, 2022, defendants discriminated, retaliated, and wrongfully terminated plaintiffs in retaliation for reporting labor codes and OSHA violations to his superiors. Then it goes into how he suffered from, emotional and mental anguish and embarrassment, humiliation, and all of that because of his termination. And let's move on to page 6. Now, it starts with the continuation of the first action, which most of these actions all look the same, and they just talk about the conduct, what was alleged, and then how he wants punctual damages and attorney's fees covered for this. Then we go into the second cause of action, which is retaliation, violation of FEHA. And if we look at number 18 or number 27, next to it, the paragraph, it says, in or about December 1st, 2022, defendants discriminated, retaliated, and wrongfully terminated plaintiffs in retaliation for his reporting labor code violations to his superiors. Defendants' retaliatory conduct was a substantial factor in causing plaintiffs harm. And again, it's pretty much the same thing about compensation and other employment benefits that he wants and his earnings, all of that. And again, how he suffered from mental, emotional, all of that, embarrassment, anguish, humiliation. Now, on to page 7. It's the same thing from the second, how they're seeking to amend the complaint if they need, but have the amount set at trial for what they should be compensated on. Now we'll go down to the third cause of action, failure to prevent discrimination, harassment, and retaliation. And again, it's pretty much all the same thing. Defendants violated this subsection by failing to take all reasonable steps necessary to prevent discrimination and retaliation from occurring against plaintiffs. Again, same thing. It goes into what the plaintiffs have suffered because of this. Let's move on to the next page. It continues with what they are trying to recover and all of that. Now we go on to the fourth cause of action, which is wrongful termination in violation of public policy, where it states that plaintiff's employment was terminated as a result of defendant's violation of fundamental public policies. It is against fundamental California public policy to discriminate and harass an employee on the bias of reporting illegal activities. Again, it goes into what they suffered because of this. Now on page 9, it goes into, again, what they hope to gain from this. And now we look at the fifth cause of action, which is violation of Labor Code 6310. Now, California Labor Code 6310 subdivision A1 prohibits an employer from discriminating against an employee who makes any oral or written complaint. Subdivision B provides that any employee who is discharged, threatened with discharge, demoted, suspended, or in any other manner discriminated against in the term and conditions of employment by his or her employer because the employee has made a bona fide oral and written complaint to his or her employer of unsafe working conditions or work practices shall be entitled to reinstatement and reimbursement for lost wages and work benefits caused by the acts of the employer. And then it states between May 2022 and December 1st, 2022, plaintiffs made oral complaints to defendants about labor laws and OSHA violations. In response to that complaint, plaintiff's employment was terminated. Again, it goes into the suffering, what these plaintiffs suffered, and the damages and all of that, what they seek at trial, which continues on to page 10. Now, we're on to the sixth cause of action, which is failure to provide rest periods in violation of Labor Code 226.7. No breaks? So it says, pursuant to the provisions of Labor Code 226.7 and the applicable Industrial Welfare Commission's order, defendants were required to provide each of their employees with a rest period of 10 minutes, during which the employees were to be totally relieved of all duties. Said rest period must be provided for each 4-hour period worked in any single day. Defendants violated the Labor Code and the Industrial Welfare Commission order and failed to provide employees, including plaintiffs, with a proper rest period. And listen, I've worked at a restaurant, and sometimes it's even hard to go outside for even 10 minutes just to rest, because you have tables, you have people, but you make that time. You have to sometimes figure out when is the best time for you to take a 10-minute quickie, like per se. I don't know how it is there. They might have to schedule it. Now we're moving down to the 7th cause of action, which is waiting time penalties in violation of Labor Code 203, which, as we can see on page 11 here, defendants and each of them willfully failed to provide non-exempt employees prior rest periods and failure to pay plaintiffs their wages due upon termination of their employment. So I do know, like in my state, if you are fired, they have to pay you within 24 hours. Now, if you are the one that just walks out, they have up to the next pay period to pay you all of your wages due. So I'm not sure what California's is or if that's what they abided by either. But it says by failing to timely paid said wages, defendants and each of them are liable to plaintiffs for penalties pursuant to Labor Code 203 in an amount equal to 30 days. Now we're going to go down to the 8th cause of action. We are almost there, guys. Unlawful business practices in violation of BUS and Proof Code 17200. They got me there. But it's Business and Professional Code Section 17200, which provides that unfair competition shall mean and include any unlawful, unfair, or fraudulent business act or practice and unfair, deceptive, untrue, or misleading advertising. So pretty much they were not practicing good business or professional code. Let's go on to the next page to read more. So they really didn't describe what unprofessional business code practice that they didn't do. They just go right into, the suffering and what they are seeking. And we have then the 9th cause of action, which is defamation. And notice the 9th says by Hill only against all defendants. So it's not all the plaintiffs. And it says defendant published false statements and comments to numerous third parties concerning plaintiffs' professionalism, reputation, and character. Said rumors and false statements were understood by the individual who heard and read them. Said rumors and false statements directly impunged plaintiff's character, calling him a criminal and fraudster imposter. Had to give you a little zing there. It then goes into, how they were acting in malice when they said these statements to humiliate the plaintiff. And it goes into special damages included but not limited to loss of income, employment related opportunities, all of that for him. And we can go on to the next page, which is our last cause of action, the 10th one. And it's only for Hill only again, which is blacklisting Labor Code 1050 and 1054, which states These statutes require defendants to refrain from blacklisting any employee or former employee to keep him or her from obtaining employment elsewhere. The plaintiff has been prevented from obtaining employment because defendants has made misrepresentations about his performance and their true reason for terminating his employment. Specifically, defendants falsely told prospective employer, the classic cat, that plaintiff is incompetent, incapable employee, and a liability. There's that bad business code. And what they did, they went to another business and said, hey, this guy is incompetent, he's incapable, and he's a liability. And then it goes into how he suffered from this and what he is trying to obtain from this. And finally, our last page, prayer for relief. Wherefore, plaintiffs request that the court enter an order of judgment against the defendants in each of them as follows: for general and special damages according to proof, for wages for missed rest breaks pursuant to Labor Code 226.7 in the amount to be determined at trial, for waiting time penalties pursuant to Labor Code 201-203 in the amount to be determined at trial, for attributable damages pursuant to Labor Code 1050 and 1054, for restitution of all unpaid wages and or disgorgement of all revenues and profits, for interest of all unpaid wages at the legal rate according to proof, for punctual and or exemplary damages, for costs of suit hereon including attorney's fees according to proof and applicable law, and for such other and further relief as the court deem just and proper. Demand for jury trial is the last part, and it is signed by the plaintiff's attorneys. So there you have all of the court documents. Now, this isn't the first time Lisa or Ken have been to court for a wrongful termination case. When I actually searched her name in the California judicial branch system, there was another wrongful termination case back in 2012, another case for other employment complaint case from 2012 as well, along with another one from 2020, another one from 2019, another one from 2020, and another one from 2020. These are all different cases that she's had to deal with. So this is not the first wrongful termination case, let alone an employee complaint case. I do not know if any of these are related to the one that she is currently being sued for. It is something that I will look into for us, though, as well. That's it for Lisa Vanderpump's lawsuit. Let me know down below what you think. I don't know if this will go to trial, but I will keep an eye out for any new filings, and I will update you all for sure. Speaking of updates, let's move on to the Ariana suing Tom to sell the house. Let's get an update there. So if you haven't seen my video already about how Ariana is suing Tom to put up the house for sale and then divide the assets, that was done on January 5th when she filed the complaint, and they had to, of course, now serve Tom and the Citibank that are the defendants in this case. And I do have update of the proof of service, which means that Tom and the bank both got served their summons to the courthouse. So here we have the proof of service summons. And you can see it was party served, Tom Sandoval, where it was served, which was at home. And it was done on January 9th at 5:24 p.m. And it also says, I personally delivered the documents listed in item 2 to the party or person authorized to receive service of process for the party 1 on date Tuesday, January 9th, 2024 at 5:24 p.m. Now, this proof of service is for City National Bank. Again, this was done at a business instead, since it is the National Bank. And it says, I personally delivered the documents listed in item 2 to the party or person authorized to receive service of process for the party 1 on date Tuesday, January 9th, 2024 at 1:44 p.m. So that means that both parties for the defendants have been served, and next will come a court date or a new filing from his side, which I will definitely be updating you all as soon as that is done. So make sure to subscribe to my channel, and after you subscribe, go back where the notification bell is and hit notifications to all so you get notified every time I post a video or go live. So, what do you guys think about all these new court cases going on with all these Vanderpump people? I would love to hear what you have to say, so also make sure to comment down below and let me know what you think. Let me know what you think is going to happen. I would love some predictions. What I think is going to happen with the whole Lisa Vanderpump and Ken wrongful termination, there's a lot of causes there. So I think that some of those might be thrown out the window, and maybe they would settle before actually going to court, let alone a trial and all of that. I do think, though, with Tom, the way he is with the Ariana and Tom situation, that he's going to push it until he can, and outcome will be that they have to sell the house anyways. But those are my prediction. What are yours? And I hope you guys have a lovely night, and I will see you guys again soon. Bye, everyone.
Win at life, have no shame, there's no time, feel the pain, live the grind, I could change, in my mind, pick a lane, commit and climb, the only way to win at life, I never miss, that's fact, taking big swings, bitch, hand me the bat, put me in the ring, you'll go out in a bag, cause I sing what I mean,